Mr. Deputy Speaker, further to the comments I made last week in this honorable House that good governance legislation would be tabled imminently, I rise today in anticipation of the subsequent tabling of some of the good governance legislation at the appropriate agenda item. Mr. Deputy Speaker, this is a matter that the government takes most seriously, and I signaled my intent to Cabinet a couple of months ago. Research and due diligence was done in the intervening period in advance of giving specific proposals and preparing the necessary legislation. My heartfelt appreciation goes to the civil servants who provided research and advice to me, as well as to the Attorney General's chambers. And in particular, I single out Ms. Catherine Balfour Swain, the Chief Parliamentary Counsel. They delivered in stellar fashion, and I'm most appreciative. Mr. Speaker, good governance has been a priority of mine since I was appointed the Finance Minister in 2004. I have spent a considerable amount of time fighting for Bermuda's credibility around the world, and we have made good progress. However, on the domestic front, there are some issues that still need to be addressed, and this government's credibility with the people of Bermuda is just as important to me as our credibility overseas. I want Mr. and Mrs. Bermuda to be assured that any hint of inappropriate behavior or wrongdoing found will be addressed swiftly and without hesitation. Mr. Deputy Speaker, this bill encompasses a number of amendments relating to good governance, including establishing the Office of Project Management and Procurement, strengthening the Internal Audit Act, and introducing a whistleblowing measure to the Employment Act 2000. The bill will address all of the basic tenets of good governance, including 1, enhancing oversight and control by A, establishing the Office of Project Management and Procurement and setting out the functions of the director. B, requiring all public authorities, particularly quangos, to comply with financial instructions and the Code of Practice for Procurement. C, amending the Internal Audit Act to include a clause which provides that the Director of Internal Audit's power to obtain documents trumps other statutory provisions or rules of privilege that would otherwise prevent the disclosure of documents or information. And 2, the basic tenets include ensuring best practice and transparency by A, introducing regulations defining financial instructions and a code of practice for procurement, and B, providing for an annual report on procurement to be laid before the legislature. It also includes Tenet 3, demonstrating zero tolerance for non-compliance by creating offenses for A, non-compliance with any part of the Public Treasury Administration and Payments Act and its associated regulations. B, a public officer involved in the awarding of contracts who does not disclose a conflict of interest, whether legal, fiduciary, beneficial, family, or otherwise. C, willfully destroying or concealing documents and increasing the penalty for such offenses. And this offense has also been introduced in the Internal Audit Act and Audit Act. And D, increasing the penalties for certain offenses in both the Internal Audit Act and the Audit Act. And the 4th tenet is protection of those who expose wrongdoing by introducing a whistleblower clause to the Employment Act to provide a new ground of unfair dismissal if a person is dismissed for making a protected disclosure to the Bermuda Police Service or other relevant agencies that are responsible for investigations. Mr. Speaker, or Deputy Speaker, honorable members may ask why we have not included an offense of provision of inducements to obtain preferred treatment in these amendments. The reason is that there is already legislation in place and has been in place for a long time. Honorable members will be aware of Section 111 of the Criminal Code Act 1907, which states that any person who being A, employed in the public service or being the holder of any public office and being charged with the performance of any duty by virtue of such employment or office, not being a duty touching the administration of justice, corruptly asks, receives or obtains or agrees or attempts to receive or obtain any property or benefit of any kind for himself or for any other person on account of anything already done or omitted to be done, or to be afterwards done or omitted to be done by him in the discharge of the duties of his office, or B, who corruptly gives, confers, or procures, or promises or offers to give, or confer, or to procure, or attempt to procure, to, upon, or for any persons employed in the public service, or being the holder of any public office, or to, upon, or for any other person, any property or benefit of any kind on account of any such act or omission on the part of the person so employed or holding such office, is guilty of a misdemeanor and is liable to imprisonment for 3 years. Members of Parliament are also not exempt from this type of legislation. In fact, the penalties for honorable members are even greater. Section 15 and 16 of the Parliament Act 1957 states in Section 15, any member of either house of the legislature who asks, receives, or obtains, or who attempts or agrees to receive or obtain any bribe, fee, compensation, gift, reward, or other property, or any other benefit of any kind for himself or for any other person, upon the understanding that his vote, opinion, judgment, or action upon any question or matter arising or expected or likely to arise in that house or in any legislative committee, A, is to be influenced thereby, or B, is to be given in any particular manner, or C, is to be given in favor of any particular side in any question or manner, or that he should absent himself from the House or legislative committee, commits an offense against this act. Punishment on conviction on indictment, imprisonment for 5 years, or a fine of $84,000 or both such imprisonment and fine. And then there's also the provision under Section 16 of the Parliamentary Act of bribery of a member an offense. Any person who, A, in order to influence a member of either house of the legislature in his vote, opinion, judgment, or action on any question or matter arising or expected or likely to arise in that house or in any legislative committee, or B, in order to induce any such member to have absent himself from that house or from any legislative committee, gives, confers, or procures, or promises or offers, or agrees to give or confer, or to procure, or to attempt to procure, any property or benefit of any kind to, upon, or for such member, or to, upon, or for any other person, commits an offense against this act. Punishment on conviction on indictment, imprisonment for 5 years, or a fine of $84,000, or both such imprisonment and fine. So, Mr. Deputy Speaker, while I feel very good about the introduction of these measures, I must state that as Premier, I have a responsibility to ensure that concerns about past projects in some key areas of government are investigated. And this bill provides an enabling framework to ensure that a rigorous review is conducted when there are queries, and the full results of that review will be shared with the House. The good governance legislation is not a tool used in a vacuum. It will work in tandem with other powers, and I anticipate that where thought fit in the circumstances, I would also reserve the right to appoint an independent team which could include a forensic specialist where circumstances warranted it, even if it is in the absence of a suspicion of criminality. And the charge of the people's purse demands no less. Mr. Speaker, this is only the first step in our endeavors to introduce measures to enhance good governance. As I mentioned last week in my ministerial statement concerning the Office of Project Management and Procurement, our interim director is well on her way to producing the code of practice on procurement. The same progress is occurring in relation to the Financial Instructions Regulation. In accordance with the negative resolution procedure, we will gazette the regulations as soon as they are produced and lay them before the House in the next session. We will also be expanding on the offense of provision of inducements to obtain preferred treatment. Honorable members will be aware that we had agreed in principle to have the UN Convention Against Corruption extended to Bermuda by the United Kingdom. Providing inducements to obtain preferred treatment has been identified as a widespread phenomenon internationally in business transactions, including trade and investment, which raises serious moral and political concerns, undermines good governance and economic development, and distorts international competitive conditions. To be effective, the proposed act must be broad in scope, capturing the offense of providing inducements for preferred treatment within both the private and public sectors, as has been done in other jurisdictions that have introduced this legislation. We have learned from the experience of these jurisdictions, particularly the United Kingdom, which enacted the Bribery Act 2010 on the 1st July this year, that we must approach this with care and diligence and undertake widespread consultation with the business community. We will be further extending the whistleblowing protection to include small businesses, which may have experienced and been the victims of unfair practices, but are afraid to speak out for fear of being blacklisted from future opportunities. Mr. Deputy Speaker, in speaking about the UK Bribery Act, I must advise honourable members that they should take careful note that Section 12(4) of that Act does extend to British citizens and British overseas territory citizens that reside outside Britain, even if the offence defined in that Act also occurred outside the United Kingdom. This has wide ramifications for our constituents in Bermuda, and we're keeping a watching brief on the outcomes of that act. Mr. Deputy Speaker, while I will be the first to state that this government is not perfect, and I'm prepared to accept criticism when we have erred, I cannot and will not accept criticism that this government has done little to enhance good governance. I must remind honourable members that it was this government that established the Office of the Ombudsman. It was this government that established an internal audit department and enacted the Internal Audit Act. It was this government that introduced the Public Access to Information legislation. It was this government that enacted money laundering and proceeds of crime legislation and established a financial intelligence agency. It was this government that caused the Bermuda Monetary Authority to become an independent regulatory body. And it was this government that enacted the International Corporation Tax Information Exchange Agreement Act and have so far signed 25 agreements. And it is this government that is tabling the Good Governance Bill. And we are not yet finished. Thank you, Mr. Speaker.
Thank you. Thank you very much, Honorable Premier.